President and Director of Community Relations. I want to welcome all of you here today. This is the second part of the hearings that have been happening today. Just a brief security announcement. In the event of an emergency or fire alarm, the exits are on this side, and in the back of the room. Thank you. All rise. The Honorable, the Supreme Court.
Thank you all very much. Good afternoon. Please be seated.
Titled Athens School District et al. Versus State Board of Education et al. Docket numbers 2019-185 and 2019-241. Representing the appellants, Athens School District et al. Is Dave Kelly. Seated at council table with Mr. Kelly are Stephen Codius, Dorothy Naylor, and Nicholas Lowe. Representing the appellee, the State Board of Education et al. Is David Boyd.
Okay, thank you. I want to make sure council, both sides, know we have a card system for time here. The bailiff on the side will hold up the number of minutes that are left in your time, and we'll try to make sure that you see it before the card comes down. Okay? All right, council, come on up, please, and proceed.
Good afternoon. May it please the court.
Good afternoon.
I'm honored to be here and to be able to speak on behalf of the school districts, the students, the parents, and the taxpayers who have brought this appeal. Very briefly at the outset, I would like to list 5 reversible errors. First, the board violated Act 46 by failing to find mergers necessary as required by Section 10B. Second, even if the board had made a necessary finding under 10B, its forced merger order violated Chapter 11 of Title 16 by failing to allow required votes. Third, if the legislature had intended to delegate the authority to order forced mergers, that without those votes, that delegation would have violated our separation of powers doctrine. Fourth, the education clause of our Constitution says each town, not region, ought to maintain a competent number of schools, and the 1964 amendment was intended to permit towns to choose union schools, not force them to do so. Finally, 5, the board's order violates the Common Benefits Clause because it creates 2 separate classes of students, those in voluntarily merged districts who now get millions in additional funding, and those in forced merger districts who are denied that funding, even though many of them have far higher poverty rates. So let me go first to that original point. The plain, unambiguous language of Act 46 required forced mergers to be necessary. The legally operative language is in Section 10B, and I quote, "The board shall publish on the agency's website its order merging and realigning districts and supervisory unions where necessary." Where necessary. To be clear, Section 10A says, to the extent necessary to achieve the goals of Section 2. Look at page 133 of the printed case. That section of the agency's proposed plan is entitled Act 46 Disfavors the Continued Existence of Supervisory Unions Where Merger is Possible. That's just plain wrong. That's legally incorrect. I would refer you to page 6 of the board's November 28th order. The board freely acknowledges they have merged districts wherever possible and practicable.
I'm sorry, Director, I'm looking at that language that you referred to, the necessary language, and I understand the argument. But when I refer back to Section 5, and the statute says, on or before July 1st, 2019, the state shall provide educational opportunities through sustainable structures defined to meet the goals pursuant to one of the models described in this section. And so I'm wondering whether, I understand if you looked at the language in Section 10 by itself, you've got this necessity requirement. If you look at this by itself, it suggests that the statute intends to say you're either a preferred structure or you fit the parameters for an alternative structure, and there's no third category of things that it's not necessary to do anything, which is, I gather, the category you're advocating for.
No, not at all, Your Honor. I think it's perfectly reasonable to expect an approved Section 9 proposal to be part of an alternative structure. If we have a district that's meeting all of the goals, that's affordable, that has terrific academic outcomes, and it satisfies and has provided the comprehensive data that's required and requested by Section 9, then that district would be part of an alternative structure.
Is the analysis of whether the goals are being met conducted on through the lens of the districts as they currently exist, or through the lens of regions, such that one district may in its own right be meeting the goals, but because of factors in surrounding districts, the region as a whole is not, and that district's participation in some sort of plan is necessary to get you to a preferred structure?
Well, I think there's two parts to the answer to that question. First of all, we need to keep in mind the preeminent goal of Section 2, to encourage and support local decision making. But then secondly, I think you need to look at Section 8. Section 8 refers to the early approval of voluntary mergers. And they say there that if there is a district with high rates of poverty, or a district that might be isolated because the proposal for an alternative structure omits one of those districts, then we need to look at what's in the best interest of the region. Because what we don't want to do is abandon some district because of high rates of poverty or leave some district out there all alone. On the other hand, what it says in Section 10 is the board must consider Section 9 proposals. Because if we have a district that's doing everything right, that has affordable costs, that has great academic outcomes, it makes no sense. You know the old Vermont saying, if it ain't broke, don't fix it. It makes no sense to throw them in a pool just because it's possible to merge them.
Well, you said it is important to look at what is in the best interests of the region. But the policy of the legislature, as I understand it, was in a broader context. Put the problem into a broader context. And in fact, I'm looking at 121 of the printed case, where the secretary's executive summary, she says Act 46 was passed in response to many other factors, in response to, among other factors, a substantial change in the state's demographics. Over the past 20 years, consistent with trends across rural states generally, Vermont's student population has shrunk by more than 24%. Act 46 offered districts a package of phased tax reductions and other transitional assistance in exchange for merging small, usually single-town school districts into larger, more sustainable governance units. So what isn't the context of this represented by that language, that this is what the legislature was struggling with, a statewide problem with respect to education?
Certainly, Your Honor, but I think there's two important answers to that question. First of all, it would make no sense to include the necessary condition of Section 10 or to even have a Section 9 telling districts that expected to retain their current governance structure that they could do so by providing comprehensive data that demonstrated that they were meeting or exceeding the goals of Act 46. I think, secondly, in answer to your question, what we need to do is see exactly how the legislators who wrote this law answered that question. We noted in our brief that Senator Zuckerman, just the day before passage of the bill, said if your district does it well financially and with outcomes, the district doesn't have to change a thing. Senator Benning, if your district is efficient with good outcomes, this bill seeks to leave you alone. The reporter of the bill, the chair of the Senate Ed Committee, Senator Cummings, said exactly the same thing to the entire Senate just before they voted on the bill. The understanding was, if it's not necessary to merge you, if you are indeed an affordable school with great outcomes, then this bill seeks to leave you alone. And you can come to us with that comprehensive data, and you can show us that you're meeting or exceeding the goals, and that it's not necessary to merge you. But it doesn't
that's only for forced mergers. Only for forced mergers, correct? On the necessity finding?
That's right. The necessary finding was for forced mergers under Section 10B. Correct.
So other than a lawsuit, what's the check on the decision-making process of the state board?
Your Honor, that's a great question. One of the difficulties here is that we have a board that has really had no expertise in designing government programs or in designing municipal governments. And they started from scratch with just one sentence saying you should write default articles of agreement. But the check is the voting rights that are set forth in Chapter 11 of Title 16. Those voting rights were never repealed. In fact, they were very consciously left in place because in Section 8 of Act 49, the legislature said to three of the most important organizations, including the Agency of Education, tell us what voting rights need to be repealed or amended here. And the answer came back, none. In fact, part of that answer said the electorate retains the right to vote on the assumption of debt or the transfer of property.
That's in Chapter 11, correct? That's in Chapter 11, Title 16?
Exactly, that's in Chapter 11. In fact, it's interesting, Your Honor, because the defendants, the state, used Chapter 11 throughout their default articles of agreement. They used the voting rights in 706N for amending articles of agreement. They used the voting rights in 721. In fact, what they said they did, Your Honors, is use 1/2 of the voting rights in Section 721 and ignore the other half. They treated the voting rights in Chapter 11 of Title 16 as if they were an a la carte menu. You don't get to pick and choose the statutes you want to use. And the voting rights in Chapter 11 of Title 16 were left in place. And I think this court's very wise decision in the Rutland Tax Challengers case makes it clear, very importantly, that a right as fundamental, as much of a bedrock of democracy as the right to vote does not get repealed by implication. If we are going to repeal the right to vote, we need to do it forthrightly in the sunlight, not in the shadows by implication.
You made the comment that the board is not experienced in doing this kind of assessment. But they have been doing this, haven't they, under Title 16 in the area of voluntary mergers? The board has to, after a study has happened and a plan has been put forward, the legislature has delegated to the board the ability to, and the authority to determine whether that merger is appropriate or not.
Your Honor, I would submit that the board's expertise is in educational policy. Never, ever before have they done any kind of municipal design. In this particular case, what they've done is create new municipalities, define new electorates, dissolve existing municipalities, create extra statutory procedures for warning and conducting electorates, remove existing elected officials from office, create new public offices for new political bodies, appoint existing school board members to new public offices with powers for which they weren't ever elected, authorize new boards to incur millions of dollars in debt and to spend taxpayer dollars raised for an entirely different municipality. All of this they've done and they've designed with no votes of the electorate. And I would submit to this court that those actions go directly against the grain of Village of Waterbury versus Melendi, as well as in-re municipal charters. It has been understood in this state that the people who are really the right people to design municipal governments are the elected representatives, our elected representatives in the legislature and local governments. But we don't delegate this kind of discretion to an executive agency.
So let me ask about that, because there's nothing in the Constitution that says either the legislature or local government. It just says the legislature. And so I'm trying to figure out, once you concede that it's okay to have statutes that allow school districts as municipalities to form and reform themselves and reconfigure without the intervention of the legislature, aren't you essentially acknowledging that there are contexts in which the legislature can in fact delegate the authority to do that to some other body?
Your Honor, I think the court's reasoning in those cases is very sound. What the court has said is, in a town like Franklin, which I might add voted unanimously against merging, not one single dissenting vote. The board, on the other hand, votes 7-2, and the 2 dissenters are here today, I'm grateful to know, voted 7-2, despite that unanimous vote that they should be merged. The logic behind the court's decisions in those cases is the people in the local municipality are interested in local issues. They have knowledge about local issues. They're invested in local issues. And their elected representatives in the legislature likewise have that kind of knowledge and expertise.
That seems like a good policy argument for why you might want to have that distinction, but I don't understand how that addresses the question of whether under our Constitution the legislature is the exclusive body to define the contours and powers of municipalities.
It has been a long-standing ruling of this court, and it's not just this court, but it's law across the country. The law across the country strictly curtails the power of executive agencies to manage, create, or dissolve municipalities. And in Vermont, school districts are municipalities by statute. They have taxing power, they have their own governments, they have their own strict boundaries by town. They are municipalities. And that has been the law, and I think it's good law. It's been the law in Vermont since the early 1900s.
To the extent that there's we were talking about what other states do relative to municipalities, to the extent that many of those states also say school districts are not treated the same way as other municipalities, that legislatures can in fact delegate to administrative agencies, not just to municipalities themselves, the ability to form, reform, define school districts. Does that suggest that maybe school districts are different?
Well, you know something? It's very interesting when you look at the constitutions of all of the states around the country. We can find no constitution that's identical to Vermont that says each town shall maintain a competent number of schools. We have focused.
Well, it doesn't use shall, it says ought,
Ought.
doesn't it?
Yes,
O-U-G-H-T.
Compel, cop. You're absolutely right, ought.
Yeah.
Which I think my understanding is compelled by obligation, ought. But that's the word it uses, yes. And we are unique in that respect. And I think it's important to keep that in mind, that town government has been a critical backbone of our democracy.
If the statute had been designed, or the act had been designed to allow for the board to make a recommendation back to the legislature, and then the legislature take an up or down vote on the recommendation, would that have cured some of the ills of which you complain?
Your Honor, I think that would have been constitutional, yes. Yes, I do.
Thank you.
I would like for a minute to talk briefly about the education clause because I think it's important. When we say each town, we don't say each region. there is a constitutional obligation to maintain a school or schools, and the General Assembly can allow or consent to towns choosing other provisions. The decision to close a school in Vermont has traditionally been left in the hands of a town. The words, "unless the General Assembly permits other provisions," were inserted in 1964. And the public record shows the intent at that time was to allow the town to choose tuitioning or a union school as an option. It was not intended to empower bigger towns and bigger communities to close a smaller town's school. The legislature actually wrote in Section 3 of Act 46, "It is not the state's intent to close schools, and nothing in this act shall be construed to require, encourage, or contemplate the closure of schools in Vermont." Yet, by virtue of the default articles of agreement that were designed by the board, we have created a scheme wherein a large town with the most votes, regardless of affordability, regardless of efficiency, regardless of any of the goals of Act 46, can close a smaller neighbor's school. If they need more tuition dollars, if they want more students, they can take them.
The language that you're using, I understand the concept that you're getting at, but once it's a merged district, it's not actually one town closing another town's schools. It's a unified district voting to close one of its schools.
Except that in a situation like, quite frankly, you can find around the state of Vermont, let's take my home district, Greensboro, as an example. I would urge you to look at page 88 of the printed case and ask yourself, what was the reason for forcibly merging Greensboro with Stannard, Woodbury, and Hardwick? The plan and the board's final plan give you no reason whatsoever, except that it was possible. And the very fact of the matter is, Hardwick has 2,500 votes. Greensboro has 700 votes. Collectively, Stannard, Woodbury, and Greensboro don't have a chance. And if a larger town, like Virgins wants to close Addison and Ferrisburg, or Middlebury wants to close Ripton and Weybridge, or Waterbury wants to close Fayston and Moortown, they have the votes. If they want the money, I would like to believe that we here in Vermont can set self-interest aside. But the fact of the matter is, Hardwick doesn't want to put their children on a bus to go to Greensboro. If they want more students and they want more money, it'll come from us. And quite frankly, I don't believe that's the Vermont way. I believe we have been a state where neighbors have stood by each other, not on top of each other. I would like very much to reserve my remaining 10 minutes.
Of course, yeah, sure. Thank you.
May I do that?
Yes, please, thank you, that's fine, sure. Let's hear from the counsel for the FLE now, please.
Good afternoon.
Good afternoon.
David Boyd on behalf of the FLEs. I'd like to start by responding to a few of the questions that came up during the initial presentation, starting with Justice Robinson's about whether the analysis under Act 46 is regionally or district focused. The answer is it's regionally focused, and it's a statewide plan.
And where do we find that in the Act? Where do we find the regional focus?
The regional focus is in 8B1. The board can only approve a proposed alternative structure if it is the best means of meeting the Section 2 goals in a region. So under that framework, if a proposal was best for a district but not best for a region, the board could not approve it. The analysis must be regionally focused. And that makes sense in the context of a statewide plan under 10A, designed to ensure sustainable governance structures throughout the state.
How do you square that with the printed case, page 63, which is a memo from Mr. Mathis, who was a member of the board, indicating that, using Montgomery as an example, which they followed their instructions perfectly, they assessed each other's goals, they had high test scores with high poverty, they had increasing student population, they investigated other options, and they operated below state costs. And they had 2 negative public votes against merger, but they were required to still merge.
The answer, again, looking at Mr. Mathis' example, is Montgomery's Section 9 proposal would have needed to establish that it was best for the overall region, not Montgomery, for there not to be a merger in the region in order for the alternative structure proposal to be approved. So district-specific arguments don't establish what's best for the region. Regional arguments could or could not. So the basic structure for looking at Montgomery's as an example would be beginning in Section 5, preferred structures are preferred. Section 5 indicates that. An alternative structure would be proposed under Section 9. It would need to be data-driven, and it would need to address the Section 2 goals. The board then could only approve it if it was the best for a region in that region under 8B1. So Montgomery making arguments specific to Montgomery doesn't do that.
But when you talk about being data-driven, I mean, what information is the board using to create data-driven decisions?
The board listed the data that districts should include in its 3400 series of rules, and it's fairly extensive. It's also listed in Section 2.
How many alternate structure proposals did the board approve under Section 9?
So there I think it's important to distinguish between approve being a magic word and doing what was requested in the alternative proposals. The board did what was requested by at least 37 districts in its plan. It didn't merge about half the districts subject to the plan. It merged about half the districts subject to the plan. It didn't specifically indicate whether it was approving or rejecting alternative structure proposals. It simply did what they were requesting in many of the instances. And that's consistent with the statutory language, which requires the board to consider the proposals when it's responding to the secretary's proposed plan, but not specifically to approve or reject proposals.
Can I direct your attention to section 10A2? And I want to understand your theories to this language. It says, on or before June 1, 2018, the agency shall present to the Board of Education a proposed plan that, to the extent necessary to promote the purpose stated at the beginning of this subsection 8, would move districts into the more sustainable preferred model of governance, blah, blah, blah. If the thought was that the plan was going to move districts into the more sustainable preferred model of governance, unless it wasn't possible or practical to do that, in which case you would look at the Section 9 alternative, why would it have that language that says, to the extent necessary? What does that language add to it, or is it redundant? Are we supposed to understand it to be surplusage?
I think what the word necessary means is what the Superior Court found it meant, which was that the board needed to take actions feasible to move districts, to merge districts to accomplish the state's goals. And you can see that from the fact that the board was required to merge districts. It was necessary to merge districts for it to create either a preferred structure or an alternative structure under the plan. And those were its only two options. So if it was going to include a structure in the plan, it was necessary to merge districts.
Okay, but you wouldn't need that language if the only options were you're going to have a preferred arrangement or you're going to have the alternative, an approved alternative. Then you wouldn't have this introductory language that says, to the extent necessary to promote the purposes of subsection A, you're going to do one or the other. It feels like you're reading that to the extent necessary out of the statute, and I'm trying to.
So if you're beginning with section 10A, the only option for the plan are providing educational opportunities through sustainable governance structures designed to meet the goals pursuant to one of the models described in section 5. So there's only two models in section 5.
Okay.
Those two models are preferred and alternative, and those are the only options the board can include. So if the board's going to include one of those options, it's necessary to merge districts. It's necessary to merge districts to create a preferred structure because preferred structures are unified unions. And the only way to create a unified union from a group of fragmented separate unions is by merging them. Sorry, districts, not unions. And as to alternative structures, it's necessary to merge districts to create an alternative structure because 2 of the 5 guidelines call for alternative structures in 5C to have the smallest number of member school districts practicable.
Well, if those are the only two options and it's necessary under either one of the two, then the language to the extent necessary adds nothing.
I think it links to the guidance that the 2 types of structures you're creating are both more consolidated. And it's necessary to merge districts to create both of them, where merger is possible and practicable. If merger is not possible and practicable, the board does nothing. It can't merge districts. If merger is possible and practicable, it can create either a preferred or an alternative structure, and it's necessary to merge districts to take either of those steps. In terms of the use of the word necessary, I think it's also important to note that appellants are seeking to invert the structure of the statute from preferring preferred structures in Section 5 and allowing the board to approve alternative structures only if they're best for the region in Section 8B by using the word necessary, even though it refers to both structures in the same way. It couldn't possibly invert the statutory burdens. The reference is to including preferred structures where necessary or including alternative structures where necessary. The word necessary couldn't favor either structure type, and because it's necessary to merge districts to create either structure type, the Superior Court's reading was the best reading of the statute in interpreting the word necessary.
But doesn't the word necessary create a method so that towns that voted against it have some check on making sure that it's going to be required by an independent review? Isn't that what necessary means here? I don't know how you can read it any other way.
The check on town voting is the Section 9 process. It's submitting an alternative governance structure. Section 10 unambiguously contemplates involuntary mergers. By the time you get to Section 10, districts have declined to voluntarily merge in response to incentives. They've submitted written proposals not to merge under Section 9. They've had conversations with the Secretary about not merging, and they've made presentations to the board in which they've indicated their opposition to merging. The only way Section 10 makes sense, and the only way Sections 5C and 8B make sense, is if Section 10 contemplates involuntary mergers. So the check then is merger possible and practicable? And if merger is possible and practicable, is an alternative structure instead the best means? That's what the Section 9 proposals needed to show where merger was possible and practicable. That an alternative structure was the best means rather than the preferred structure under the Act. It's essentially shifting aside a preferred structure in favor of something better if the districts involved can demonstrate that it is. Also wanted to respond briefly to the question of whether school districts are different for delegation purposes. I think that's an important point. They are. If you look around the country, you'll see there's a divide in authority about the extent to which legislatures can delegate authority to merge or alter towns. But courts around the country have also been reviewing school district consolidation cases for decades, and more than 30 have found that authority is delegable as to school districts. Good examples of broader delegations than Act 46 are the Pennsylvania Supreme Court case in Chartiers and Delaware in Opinion of the Justices. And appellants have not cited any cases involving school districts or cited anywhere, finding that that authority can't be delegated.
So I'm trying to figure out where the line is. We've held 100 years ago that village, even though it's not listed in the grant of powers to the legislature, is forming villages is a legislative power. You're saying school districts isn't. Can the legislature delegate to an executive branch agency the authority to form regional municipalities for the purposes of recycling management or other things like that?
I think the line would likely be in both the scope of the powers of the entity that you're talking about. That was a major factor in municipal charters. There were about 20 listed powers in the statute, one of which was to operate schools. And also the extent of the standards provided along with the delegation. I think the more modern delegation cases have looked primarily at whether there are adequate standards to guide the discretion of the agency, as opposed to whether the delegation is essentially to make the law and then implement it.
Okay, so other than a lawsuit, what's the check on the state board's decision to order a forced merger?
It's the same as any other check in a democratic context. It's your legislatures, your legislators.
Well, explain to me how that would work. You're talking about removing and replacing senators and representatives?
Yes, if you disagreed with the way your legislators voted, you would vote for someone who would support changing school districts in a different way. I mean, this is fundamentally a democratic process. The state legislature decided that there was a statewide problem it needed to address, a major decline in enrollment that was unevenly distributed around the state, and that was driving costs and create a vicious cycle in smaller districts. One of the goals was to allow smaller districts to have the expanded economies of scale and educational opportunities in larger districts, and Act 46 was the legislature's decision about how best to implement.
I presume that if the board exercised its delegated authority in a way that was inconsistent with the guidance given by the legislature, that would be, you wouldn't deny that that would be something that a court could rectify. They exceeded their delegated authority.
So I think there's a distinction there between what the statute provided, which would be covered by a typical declaratory judgment action, and what would be covered under Rule 75 review.
Okay.
The appellants below, or the Superior Court below, found that the board was acting in a quasi-legislative capacity, and that finding wasn't appealed. There's no mention of Stratton in the principal brief. There's no discussion of it in the statement of issues. The first time it's mentioned is in the reply, which I would encourage the court to disregard that as being first mentioned in the reply. And the consequence of that is that the review is covered by Lake Bomoseen, this court's decision in Bomoseen, where the court found that if a statute contemplates a quasi-legislative action by an agency and it's silent as to judicial review, General Rule 75 review is not available, because review of legislative proceedings and quasi-legislative proceedings was not historically available by extraordinary writ.
So you're now arguing that we have no jurisdiction to review this at all?
No, the court can review the statute. It can review everything that would be covered by declaratory judgment action, but it wouldn't have General Rule 75 review under the logic of Bomoseen. And I would also,
Go ahead.
didn't mean to interrupt if there was
No,
a
no,
question.
I'm set.
Would encourage the court to look at what review is available through the framework of professional nurses and a generally deferential standard of review. I think that's consistent with Rule 75 review generally, as well as the board's experience ordering mergers, which is in many respects more of a factor than whether the proceeding is classified as legislative or adjudicative. Either way, if the agency is construing a statute within its expertise, review is typically deferential.
You say agency, we're talking about the board.
Yes, the board.
With respect to, there were some comments from legislators that were referenced by opposing counsel about the impact of Act 46 on schools that are performing well and meeting cost goals, even though they may be smaller schools, that they would be okay and not subject to worry under Act 46. Are you suggesting now that those comments were mistaken?
I think it's important to note when those comments were made and who they were made by. The reply indicates that, quote, the legislators who crafted the law were clear as to their intent when they presented Act 46 to the full Senate for a vote. And then it quotes Senator Cummings, quote, speaking to the Senate floor at the time it passed. Act 46 was not crafted by senators, it was a House bill, and it didn't pass on May 7th, which is when the quoted statements were made. The May 7 version the Senate was considering was materially different than the final version. It didn't have a Section 2 listing goals. It didn't clearly identify the goals that alternative structures were required to meet. It made merger support grants temporary, not permanent. It didn't change small school grants in the same way. It didn't require Section 9 alternative governance proposals at all. They were optional. It didn't contemplate the board issuing a final order merging districts at all. It contemplated the board proposing a plan to the legislature. And it didn't include a Section 8B indicating that the board could only approve alternative structures if they were best for a region. At the time those statements were made, it was certainly true that the bill didn't require districts to make any changes. It didn't require them to make proposals at all, and it didn't contemplate the board making an order that would go into effect. I would also say that the plaintiffs could not rely on those quotations to contradict the text of Act 46, even if they had been relating to the final version of the Act. Act 46 passed in 2015. In 2016, the board promulgated draft rules for the submission of alternative governance proposals. Those rules quoted the best means requirement in Section 8B and stated in Rule 3450.3 that a proposal was required to demonstrate that a preferred structure, quote, is not the best model to achieve the goals in the region. The first senator quoted by plaintiffs, Senator Cummings, responded by sending a letter to the board objecting to that best model discussion. Plaintiffs allege that in paragraph 101 of the complaint. Another one of the quoted senators, Senator Benning, sponsored S-15, which was an unsuccessful Senate bill that would have removed the best means requirement from the statute. The summary of S-15 also contradicts the appellant's argument that Section 8B was only intended to apply in the initial phase of Act 46, as opposed to when the statewide plan was being prepared. It states that S-15 would have required the board, quote, to evaluate alternative structure proposals on a case-by-case basis, as opposed to only on the back end as part of the statewide plan. The plaintiffs are asking the court to rewrite Act 46 based on statements from senators who asked the legislature to do just that, and the legislature declined. Rather, the Superior Court correctly described the structure and purpose of Act 46. It was a thoughtful response by the legislature to a substantial drop in Vermont's student population, designed to allow smaller districts access to expanded educational opportunities and economies of scale within larger governance models. It expressly prefers preferred structures in Section 5, and districts that are opposed to the creation of preferred structures in their region are required by Section 9 to submit data-driven proposals, arguing that that should not happen. Those proposals could either show that a merger was not possible or practicable under 10A, or show that an alternative is the best means under 8B1. Appellants are seeking to rewrite Act 46 because they are districts that could not do that. No appellant submitted a proposal that met the guidelines under 5C for when a proposed alternative structure was likely to be best, because no appellant district submitted a proposal that proposed any mergers, and 2 of the 5 guidelines contemplate alternative structures having the smallest number of member districts practicable. In sum, appellants are seeking reversal based on proposals that did not meet the alternative structure guidelines, and without arguing that any individual proposal was best for the region.
Can I shift to the question of assuming that you're sort of describing what proposals do and don't fly? We have an argument here that the statutes require that for towns to give up debt, take on debt, etc., voters have to have an opportunity to vote on that. There's nothing in this statute that explicitly purports to override those provisions. They were left in place, and they've cited some history that suggested that they were left in place consciously. How do you reconcile those voting rights with the notion that these forced mergers aren't subject to any vote of the citizens of the town, but nonetheless transfer the debt?
First, I would say it's not possible to say that Section 10 contemplated forced mergers while saying that all of the voting rights in Chapter 16 apply, because those voting rights would veto the mergers. One of the voting rights is one of the voting statutes. Let me back up. The voluntary merger voting statutes address a different topic. They address voluntary mergers. Section 10 addresses a different topic of involuntary mergers. And if you follow the processes through, they're parallel and distinct. You can see that the two are harmonious. The voluntary merger voting process starts with districts agreeing to form a study committee to study whether a merger is advisable. If they do, they prepare a report in the form...
But aren't there voting rights that pre-exist Act 46 altogether?
Yes, the Chapter 16 of Title 11 pre-exists Act 46.
Right, so those are overarching, those aren't tied to Section 9 or Section 10. Those are baseline pre-existing rights that aren't expressly overridden by any language in this bill or in this act.
So I would disagree on the expressly overridden by looking at Section 10B.
Okay.
10B contemplates the board issuing an order merging districts. It's not merging districts unless they vote not to merge. And the only way you get to Section 10 is after districts have not voluntarily merged in response to the incentives in Section 6 and 7, and after districts have submitted proposals not to merge under Section 9. The only way Section 10 could make sense is if it was mandatory.
So why doesn't the Section 10 provision say, notwithstanding the provisions of Chapter 11 of Title 16?
It could have, but it wasn't necessary. And the reason it wasn't necessary is the two address different topics, and they're harmonious with each other. The voluntary voting statutes, you begin with a study committee, it creates a report, and then the report is approved by voters and the state board. That's how you get to the end of a voluntary merger. The involuntary merger process doesn't follow any of those steps. The districts have already decided not to voluntarily merge, or they would have in response to the incentives. Instead, they submit a proposal for an alternative governance structure under Section 9. The board then considers that proposal in the context of the statewide plan, and then it issues an order merging districts, or not, after its review of the plan and the order. And you can see that those processes are separate and distinct, in particular by looking at the default articles of agreement, because all voluntary mergers have articles of agreement. The first thing the study committee does in 706 is propose a report in the form of an agreement between districts. So every district that's created by the 706 process has articles of agreement. The only way the legislature could get to the point of 10D, of requiring the board to include default articles of agreement, is if it was requiring involuntary mergers. Because the only way a district could need default articles is if it wasn't merged by the 706 process.
And if you have default articles and a newly formed district wants to adopt different articles relating to the disposition of debt and assets, what statutory provision governs the process and voting rights relative to that adoption of alternative? Is that in this bill, or does that fall back to the full chapter 16?
So it was addressed in Act 49. The answer is 706, blanking on the letter, I want to say N.
Okay.
Yes, it was 706N. And what the legislature did when it was addressing default articles in 10D was it required the board to include them, and then it asked for proposed legislation addressing which of the articles, addressing who would need to approve changes to the default articles. And I just want to be clear about the sequence, because I think the appellants have suggested that the default articles needed to be approved by electorates. They didn't. That's inconsistent with 10D. Under 10D, the plan shall include default articles of agreement. And under 10D1, districts subject to merger have 90 days to form a committee to propose alternatives. But under 10D2, if the proposed alternatives are not approved, the default articles, quote, shall apply. So they apply immediately when they're included in the plan, and they apply unless they're amended. So the question was never whether the default articles themselves needed to be approved by the electorate. They don't. They apply immediately unless alternatives are approved. The question in 10D3 was who needed to adopt amendments if a new district proposed amending the default articles. And the answer that the legislature got from the entities it asked was that no changes to 706N needed to be made. 706N is the current statute for amendments. And it looks at when amendments need to be approved by the electorate by Australian ballot, when they can be approved by majority vote at a meeting, and when they can be approved by the union board. So the recommendation was, instead of changing that framework, that the board should include clear guidance about all of the procedural steps that districts should follow when it was issuing the order.
You see, you've got 5 minutes.
Thank you. Unless the court has further questions, I think I've covered everything I had wanted to.
Okay. Thank you very much, counsel. Does the appellant have time?
Appellant has 9 minutes and 7 seconds remaining.
Let me begin by talking briefly about the default articles of agreement, because those articles said we are transferring debt. I have here sitting with me this afternoon Dorothy Naylor, the former chair of the Calais School Board. What the board did, the unelected executive board did, was transfer $8 million worth of debt from East Montpelier to the town of Calais. There's no vote, unheard of ever in the history of the state of Vermont, done by an executive board, not by the legislature.
I want to debt transferred from East Montpelier to Calais, or the debt was transferred from East Montpelier to a newly formed district that included Calais?
That's right. It was transferred to Worcester, Berlin, Middlesex, Calais, the others.
And those districts included the taxpayers from all those towns as well?
That's right. But that wasn't done by the legislature. That was done by an unelected layperson board, 9 people voting 7-2. There was no vote, even though the background statutes that should not be repealed by implication, the background statutes say there should have been a vote. I would like to propose a question. Why would any district forego millions of dollars of tax benefits, organize hundreds of volunteers, work for thousands of hours putting together comprehensive data for a Section 9 proposal? Why would all of these districts do all of that work if they knew they would be merged anytime it was possible? To go through that exercise and to forego all of those benefits makes no sense. The understanding was they wouldn't be merged unless it was necessary. Now, my worthy colleague, Mr. Boyd, suggested we have to have some kind of a regional focus here. But I ask you to look at the merger again of Greensboro, Hardwick, Woodbury, and Stannard. Where was the benefit to the region? There is none mentioned. There is none suggested. We were merged because it was possible. And that's not what Section 10B called for.
What do we make of the legislative finding that the optimal size for a school district is 2,000 to 4,000, and that there's only 4 districts in the state at the time of the enactment that were actually within that framework of optimal size? Does that suggest that the legislature is looking for bigger districts?
You know, I think that's an interesting question, because if you look at every one of these forced mergers, they don't even come close to being a preferred structure. They are just mergers. Some of them are mergers with grades pre-K through 6, some pre-K through 8, some are mergers with 300 students, some with 100 students. And I want to suggest that it's important to keep in mind, no Section 9 proposal was ever approved. The fact of the matter is, if you look at some of the districts that Mr. Boyd was talking about, the ones that weren't merged, look at Danville and Cabot. The board said, you know what, we don't think these are affordable, we don't like the outcomes, but we're not going to merge these people because we're a little concerned about shifting Cabot's debt to Danville. That was the reason for not merging. They weren't achieving any of the goals of Act 46. On the other hand, they could shift $8 million from East Montpelier to the other districts in that supervisory union. I think it's important, when we talk about the word necessary, to look at the lower court's definition of the word necessary. And that definition is necessary in Section 10A2, this is on page 11 of the printed case, reflects a recognition that the board will have to take certain actions to achieve mergers, which in turn will meet the legislature's stated goals. That's not what the word necessary was used for. It's not what it meant in either Section 10B or 10A. The purpose was not to merge wherever we could merge. The purpose was to merge to meet the goals. And if we had districts who were doing that, who felt strongly that they were doing that, who could demonstrate through comprehensive data that they were doing that, and then they were merged with no explanation and no reason except simply that it was possible, we have a law that makes no sense.
So can you respond to we talked about, you emphasized the necessary language in Section 10, but I'm interested in your response to the language in 10A that essentially says that in order to provide educational opportunities pursuant to one of the models described in Section 5, which only describes a preferred model and then a Section 9 approved alternative. It doesn't mention none of the above as an additional option.
Well, it's interesting because the word necessary is used 4 times in Section 10, and it's actually used in 2 separate contexts. But the context I'm talking about is the one that's referring to why would we merge districts. And in 10A, what it says is, to the extent necessary to meet the purpose set forth in Section 10.
It doesn't say to the extent necessary, it says in order to meet the goals in Section 2, we're going to follow one of the two structures in Section 5.
It's a little further, I don't have it in front of me, but it says to the extent
Right.
necessary.
In 10A2, I get that, that's the language you're invoking. I'm just trying to reconcile that language with 10A, the introductory sentence, which specifically says we want one of the models described in Section 5. That's how I read that, and there's no qualification of...
And one of the models described in Section 5, of course, is the alternative structure.
Right.
And there's no reason why a Section 9 proposal can't be approved as part of an alternative structure. That's what it would be. And I think the clear intent of the word necessary is to achieve the goals well, the first goal, the preeminent goal, is to support and encourage local decision-making, which certainly hasn't been done when none of the Section 9 proposals have been approved.
When you say that's the preeminent goal, I mean, we wouldn't have Act 46 if we were trying to foster more local control. That was happening without Act 46, wasn't it, an attempt
Well,
to...
the additional listed goals are affordability, academic quality, transparency, accountability, and equity. And of course, those are all of the goals. But the purpose is not to merge, simply to merge, which is seemingly what the lower court suggested. The merger was a means, it was not an end, it wasn't a purpose. And when we had a district that's doing very, very well, with great outcomes and great efficiency, with a community that's really engaged, that's showing terrific results, there's no reason why that district couldn't be part of an alternative structure. It should be part of an alternative structure. But in fact, no Section 9 proposal was ever approved. The only districts that weren't merged were districts where it wasn't possible or somehow, for some reason, was decided to not be practicable. I would suggest that what we have done is we have created a system that will create more centralization, more bricks and mortar, longer bus rides, more buses, more gas. And in 1960, that might have been a good solution. And for some districts, even today, it might be a good solution. But for the small schools here who are the appellants, they're doing a better job right now the way they are. And there was no reason listed anywhere in the plan or the agency's plan, the board's plan or the agency's, that made it necessary, as required by 10B, to merge these districts. I would submit doing so, contrary to the local votes and the local interests and the requirements of the local people, actually turn something fundamental about Vermont and democracy upside down. And I'm grateful to have been able to be here and to plead for you to correct that error. Thank you.
Thank you very much. Thank you very much.
That concludes today's hearings.